Several times, intoxication due to drinking alcohol or taking other substances causes the person to lose the judgment of right or wrong. In law, however, this was no defense for criminal responsibility. In recent times, this has become a valid defense, but only if the intoxication was involuntary. Section 85 says thus, Section 85, nothing is an offense which is done by a person who at the time of doing it by reason of intoxication incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary of to law, provided that the thing which intoxicated him was administered to him without his knowledge or against his will. This means that to claim immunity under this section, the accused must provide the existence of the following conditions. Number 1, he was intoxicated. Because of the intoxication, he was rendered incapable of knowing the nature of the act, or what was doing was wrong or contrary to law. The thing that intoxicated him was administered to him without his knowledge or against his will. Director of Public Prosecution versus Beer 1920 was an important case on this point. In this case, 13-year-old girl was passing by a mill area in the evening. A watchman who was drunk saw her and attempted to rape her. She resisted and so she put a hand on her mouth to prevent her from screaming, thereby killing her unintentionally. House of Lords convicted him for murder, and the following principles were laid down. Number 1. If the accused was so drunk that he was incapable of forming the intent required, he could not be convicted of a crime for which only intent was required to be proved. Number 2, insanity, whether produced by drunkenness or otherwise, is a defense to the crime charged. The difference between being drunk and diseases to which drunkenness leads to another, the former is no excuse, but the latter is a valid defense if it is caused is insanity. Number 3, the evidence of drunkenness falling short of proving incapacity in the accused to form the intent necessary to commit a crime, and merely establishing that his mind was affected by the drink so that he more readily gave way to violent passion does not rebut the presumption that a man intends the natural consequence of the act. Thank you.